Morning. Welcome to this session of oral argument of the 5th District Court of Appeals. It's certainly our pleasure to preside over the cases that are on the docket this morning. Let me introduce the panel to you. I'm Judge Sawaya. To my right is Judge Orfinger, and to my left is Judge Lawson. And we have 4 cases on the docket this morning. Each will be, with the exception of the criminal case, allotted 20 minutes per side. The criminal case will be allotted 15 minutes per side. If the appellant wishes to reserve any time for rebuttal, we have a clock on the podium that assists you in keeping time, and let me know and I'll try and help you with that as well. If you have any electronic devices such as cell phones that may interrupt the oral argument, please turn them off. And so with that, we'll go ahead and proceed with MEDELLIN versus MLA Consulting, Inc.
Good morning, Your Honors. May it please the Court. My name is H. Clay Parker, and I represent Daniel and Susan MEDELLIN in this appeal. I'd like to reserve about 3 minutes, if I can, for rebuttal.
Okay.
This case involves the Mechanics Lien Law, Chapter 713 of Florida statutes. Daniel and Susan MEDELLIN had purchased themselves some property in Lake County back prior to January of 2008, and they were looking to build a home on that property themselves. They contracted...
Let me ask you a sort of practical question.
Sure.
Do you have any damages under your fraudulent lien count and your slander of title count other than the attorney's fees that you would collect anyway if you were determined to be the prevailing party?
Yes, we do, and we provided evidence of damages at trial. The court did not get to the issue of damages because it ruled against the fraudulent lien and the slander of title claim. However, we did provide proof of damages with respect to the costs of loans, a number of different types of damages that we presented at trial. If what we would be asking the court to do is, if it rules in our favor, the fraudulent lien claim as well as the slander of title claim, to remand the case for purposes of a hearing on damages only. And there are damages separate and apart from our attorney's fees issues.
Okay. Thank you.
So, Daniel and Susan MEDELLIN had contracted with UBUILDIT, MLA Consulting, doing business as UBUILDIT, and UBUILDIT is not a contractor. It's not a type of entity described under the chapters, under Chapter 713, which is permitted to file a lien for services where there's been no improvement to property, such as an architect, a landscape architect, an engineer, that type of thing. They're not that type of company. What they do and what the contract provides simply is that they will show Mr. and Mrs. MEDELLIN how to be their own contractor. They're a consulting company. At trial, well, let me back up a little bit. In January of 2008, Daniel MEDELLIN contracted with UBUILDIT. There were 2 parts to the contract. One is considered a planning phase where they go through a process in which they're going to determine what they're going to build and how they're going to build it. There's a $5,000 contract fee for that, and Mr. MEDELLIN paid that at the beginning. The next phase is considered...
I think we are very familiar with the facts of the case. I have another question, and that is, the trial judge in addressing the fraudulent lien count seemed to find that there was a subjective good faith, that they really thought they were entitled to the lien based on their interpretation of the contract. And my question is it correct? Is it a subjective standard or an objective standard, or does it make a difference?
Well, the problem with the court's ruling is that it did not consider multiple issues that were actually pled.
I understand.
And all it was looking at was, well, it believed it was owed money.
Right.
And actually in this case, there was an objective basis for showing that it was not owed money, and that is pure interpretation of the contract. They're saying, well, from our interpretation of the contract, we believe we're owed money. If you look at it objectively, there's no basis for the determination that they were owed money. They also brought initially an invoice for $9,000, and a week later filed a lien for $28,000. without having done any work and after the contract had already been terminated. So objectively, there was no basis for them to believe that they were owed any additional money. But more importantly, for purposes of this appeal, the court failed to consider whether or not there was actually an improvement on the property, whether or not the services that were provided were the type of services for which you could lien. We had pled all of these as basis for a basis for fraudulent lien. That is an objective basis for filing a fraudulent lien, and I have cited multiple cases in which it said, as a matter of law, if you file a lien for types of services which are not lienable, that is a fraudulent lien. So we have services that are being provided which are not for improvement, that they do not improve the property. There was absolutely no improvement on the property, and the only thing that you can lien, of course, is for work that you actually performed upon the property. And there is statutory definition of what improvement is, and there was no improvement. So, as a matter of law, there was a fraudulent lien. The court's findings that it stopped at the initial analysis based upon Chapter 713's exception to fraudulent lien, where it says that if there is a good faith basis to believe that you're owed money or a minor mistake, then we cannot find that there's a fraudulent lien. And he stopped his analysis there. That, of course, only goes to whether or not monies were due and how much money was due. It doesn't go to the other issues. So,
I guess, to me it seems like it may make a difference whether it's a subjective standard or objective, because on the issue of whether they were owed money and how much they were owed, the trial court found that subjectively they had a good faith basis for believing that they owed money. They make an argument that they are a proper party that can lien under the statute and that they did perform the kind of services like a supervisor would, and so they have an argument that they can lien. And so if it's a subjective standard, wouldn't we be sending it back for a determination of whether they had a good faith basis of believing that they were the kind of entity that could lien? If it's an objective standard, you wouldn't do that. So that's sort of why I'm asking the question.
well, I believe it's an objective standard here under the facts of this case. The objective standard applies to whether or not there was actually any improvements upon the property upon which you could lien. That's, in fact, in its brief in reply, UBUILDIT has conceded that there was no improvements to the property. This Fifth District Court of Appeals has ruled clearly in the onion skin case that I cited that you cannot, as a matter of law, put a lien on a person's property when you have not improved the property.
Unless you're an architect or...
Unless you fit squarely within the definitions of the Chapter 713. And Chapter 713, as the case law is clear, is in derogation of common law and must be strictly construed. And Chapter 713, the statute also states that this statute cannot be construed liberally. It must be construed strictly. So that if they don't fit squarely within the definition of the type of company that can lien for services, which it does not. It's clearly not a contractor. It's clearly not an engineer, not an architect. They have not alleged that they were. So if there's no work done upon the property, there's no basis for a lien. And as a matter of law, objectively, it is a fraudulent lien. I'm also asserting, Your Honors, that objectively there was no basis for them to believe that they were owed money. And I'll explain why. There are two phases to the contract. The first phase is the planning phase. He paid for that at the beginning. The contract clearly states that Mr. MEDELLIN has a right to cancel that contract at any time by simply paying what is owed at that point in time. At the end of the planning phase, and after he received a small portion of the loan on the property that he was going to use to build, approximately $20,000 of the loan that he was going to use to build, he wrote, this is undisputed, he wrote in March of 2008, and advised them that he no longer needs their services and he's terminating the contract.
Well, the contract said that the construction phase began whenever there were bids taken, correct?
Whenever, it's very vague with respect to that.
That's their argument.
Their argument is,
and
if there are bids...
Factually, you agree that bids were taken 2 weeks before he sent the letter. terminating?
I think the contract actually, if you read it as a whole, is absolutely clear. What they're talking about is we collect bids and we will provide those bids to you, along with the construction manual so you can work. Okay? And once they have that collection of bids, that is the homeowner, they have the construction manual, I understand that the company wouldn't want them to use that construction manual and their bids in order to do work. But that wasn't the case here. What they did was there were 2 bids that were provided directly to the Medellins, and they're the ones who had dealt with the companies themselves. So it wasn't coming through UBuildIt, it was coming directly to the homeowner. So UBuildIt cannot claim that because you received those bids independently, we therefore go into the construction phase. That's not obviously the intention of the contract.
And am I right that the trial court found that the contract was ambiguous?
It did find that the contract was ambiguous.
And then construed it against the party who drafted it.
That's exactly correct.
And so you won your breach of contract.
That's exactly correct. Now, in that regard, if you actually read what the intent of the contract is, there is no true basis for them to believe that they were owed any money whatsoever. However, even if we say that they're owed some money, perhaps, they say 35% which due upon delivery of the construction manual, 35%. That's the $9,000 that was invoiced. How in the world do they get the $28,000 that they liened? There's no basis under the contract for that at all. So I was at a loss to understand the court's ruling with respect to why they would believe that they were owed $28,000, which we pled and argued and believed proved that that was clearly exaggerated bill. Even excluding the idea that...
Well, they argue in their answer brief, their construction of the contract, why they believe there's some contract language that gave them the full construction phase amount as soon as the construction phase started. I mean, ultimately, maybe that's ambiguous too, and it was properly construed against them.
I think it was construed against them, and we won the contract issue.
Right.
But my point for purposes of the fraudulent lien claim is that was clearly exaggerated. That's as one aspect of the fraudulent lien claim. And I think if you actually look at the terms of the contract itself, and that is when money is due and the right to cancel, and if you look at those the contract language, I think it's you come to the conclusion that at the time that he canceled, no more money was due. I mean, just look at the terms of the contract, and I think it's clear. Be that as it may, even if we accept the fact, accept that there may be some ambiguity associated with it, the fraudulent lien occurs as well because the type of services that they provide, that is, we're going to teach you how to do your own work, and they don't accept any responsibility for the work themselves. They have a waiver of liability. They have an indemnification. They're not a contractor. Say, all we're going to do is help you be your own contractor. Those are not the types of services that are lienable under Florida, the mechanics lien statute. And I think it's important for the court to rule on that because companies like UBuildIt are filing liens in the state of Florida when they don't have a right to do that. And I believe it's important that the court rule that these types of services are not the types of services that were intended under the under Chapter 713 to be given the right to a lien on people's homes. But even if it were a construction manager, no work was done on the property. And case after case after case that we've cited to you in each one of those, if you don't do work on the property, you can't lien. Pure and simple, clear. Okay. Now, I want to go to the attorney's fees issue. There are multiple reasons that the court should have awarded attorney's fees. The first is that there were no competing claims for attorney's fees. That is, the MEDELLINs won on the breach of contract claim, the MEDELLINs won on the foreclosure of the lien. Both of those give a basis for attorney's fees. The MEDELLINs pled attorney's fees in response to their affirmative defenses to both of those claims. On the other hand, they also brought their own counterclaims for fraudulent lien and slander of title. Simply because the court ruled against the MEDELLINs with respect to the fraudulent lien claims and the slander of title claims does not mean that they did not win on the substantial issues, especially in the circumstance where UBuildIt did not plead a right to attorney's fees for defending the fraudulent lien claim. There were no competing claims for attorney's fees. So where the only claims for attorney's fees that you have a right to, my clients won on, then as a matter of law, they're entitled to attorney's fees. Secondly, if we look at what the substantial issues are, if we're just looking at the substantial issues factors set forth in the Tritech case, this Florida Supreme Court case, says you've got to, although Tritech says you don't have to necessarily have a prevailing party, and I know the court relied upon that when it ruled against my clients with respect to attorney's fees. You don't necessarily have to have a prevailing party. This case is not one of those issues. You still, under Tritech, have to go to the substantial issues factors set forth in Prosperi. So you're looking at who won on the substantial issues. Well, what's the substantial issue here? The claims brought for breach of contract were entitled to money. UBUILDIT lost. The claim brought to foreclose a lien, UBUILDIT lost. The lien was extinguished. That is an affirmative judgment for my clients. So on the substantial issues of the case, my clients won. So even under Tritech and Prosperi, they would be entitled to attorney's fees. Susan MEDELLIN was brought in as a defendant under the foreclosure of the lien only. She had no counterclaim, and there was no breach of contract claim. So she won on the only issue that was brought against her.
You've got 4.5 minutes left.
Thank you, Your Honor. What I think I will do, what we're asking the court to do is to reverse the trial court's order, because it's clear by the reading the language of the order which denies the motion for reconsideration, in which the court is stating that all it is considering is whether or not the defendants had a good faith belief that they were owed money. If that were the standard, then anyone could bring a lien on anyone on any property as long as that they believed that they were owed money. You have to look to see whether the services were the type of services which are lienable, whether any work was actually done on the property, and without that type of analysis, of course, a credit card company could put a lien on somebody, as long as they had a reason to believe that they were owed money. Thank you, Your Honor.
Sir.
Good morning, Your Honors. I'm Daniel M. Copeland, representing the appellees, MLA Consulting, and DBA UBUILDIT. Gentlemen, this case is really boiling down to whether or not my client had the right to file, was an entity that had the right to file a claim of lien for improvements on real property. And under the statute, as a construction manager, and the way the contract was written, my client qualified as an entity capable and allowed to file a construction lien. Now,
The statute doesn't say anything about construction managers, does it?
no, sir, it doesn't specifically state construction managers. However, under 489-532, if a license is not required to perform the work, then it is considered an enforceable lien and allowed to be filed. In the express terms of the contract, my client's contract clearly delineates that he is, even though it doesn't say it, he's functioning as a construction manager. He is giving advice to the owner. He is not entering into direct contracts with any subcontractors. His only direct contract is with the owner. If there are any disputes or problems... Yes, sir.
My view of a construction manager, in my experience, is that that's someone who deals with contractors on your behalf, oversees the construction, would actually probably have liability if things went bad, because they're the ones that are directing the construction. You created a contract in which you don't tell subcontractors or contractors anything. You don't have liability for anything. You don't do anything except pretty much teach the owner what they should say and what they should do. I mean, I have a hard time seeing how that's a construction manager,
Okay,
if
sir.
it matters. But
Yes, sir. And what happened in this, and where the claim of lien arose, is in Section 8 of the contract. When the contract enters into the construction phase, it clearly states that all fees that are due to the UBUILDIT are due and payable upon a draw schedule. And the amount of fees are determined, I think it was like $6.03 per square foot times the square footage of the house minus the $5,000 deposit is
Mr.
worth the 28.
Copeland, lay aside just for a minute the
Yes, sir.
amount of the claim, and let's come back to the issue of your client's right to impose a lien in any amount.
Yes, sir.
Is your sole basis for claiming the right to a lien your contention that your client functioned as a construction manager?
Yes, sir.
And if that argument fails, then you're left with perhaps a breach of contract claim,
Yes, sir.
but no right to a lien.
That is correct.
And what is your position with respect, again, and I understand you're not advocating this, but if we don't agree with you that your client was a construction manager and as a result of that don't find that your client was entitled to a lien, what do you think that does to their argument that the lien was as a matter of law fraudulent, not necessarily because the amount was misstated, but because there was no right to a lien in any amount?
Your Honor, my position is that as what the trial court found, the language of the contract that they were dealing under was so ambiguous, is there was no indication as to when the planning phase ended and the construction phase began.
Well, I understand that the contract arguably is fuzzy on when you transition from one to the other.
Yes, sir.
But irrespective of, whether you're entitled to recover $1 or $28,000, let's lay that issue aside and just focus on the idea of whether you're entitled to a lien at all. So if you're not if we conclude that your client was not entitled to a lien, whether the lien was for $1 or $28,000 or somewhere in between, what's your best argument that that lien that you imposed on the property would not be fraudulent as a matter of law?
As my argument that it would not be fraudulent as a matter of law, Your Honor, is that to determine whether or not the lien is fraudulent, the court must look at the substantial and competent evidence presented at trial. And at trial, they found that it was a good faith dispute as to monies owed to my client by Mr. MEDELLIN. And that was the basis for filing his claim. The ambiguities of the contract is what knocked out the fraud, which knocked out his right to claim a lien, which negated by finding that the contract was ambiguous, it was construed against my client. Therefore, my client was not able to collect on the contract. The court found in favor of Mr. MEDELLIN as to breach of contract. That by itself eviscerated my client's claim of lien. So the claim of lien went away based on the finding of no breach of contract by the appellant. Now, as to whether or not it's a fraudulent lien, it goes to the intent of the party filing the lien. And the court found, and under 713 2B, that a good faith basis in filing the lien does not make the lien a fraudulent lien.
Well, but doesn't that speak to a good faith dispute as to the amount due? And I certainly would agree with you. I mean, if we assume that you were entitled to a lien, you asked for $28,000 and recovered $20,000 because there was some dispute. I mean, that's one set of facts. But the question here isn't really whether, even if we were to assume that the contract was breached, which the trial court said it wasn't, but even if the contract was breached, if you weren't entitled to a lien at all, I'm not sure how subparagraph B helps you, because the dispute isn't as to the amount, but it's as to your right to lien the property at all. And that's really what my focus at the moment is trying to figure out the implications if you're not entitled to a lien at all. Mm-hmm. because it may be just because you don't know the law, a good faith mistake as to the law, whatever. I mean, I'm certainly not implying that your clients acted in bad faith, but what's your position when it says a good faith dispute as to the amount due? That doesn't really speak to good faith belief as to the right to a lien.
No, sir. No, that does not. However, we believe, based on a reading of the statutes, that excuse me, that UBUILDIT was in direct contract with an owner. There was a contract, and that UBUILDIT was providing or was going to provide services to the owner for the improvement of the real property, and that in that capacity, under the construction.
So I thought that your contract made it clear that you were not providing services for the improvement of the property. You were teaching them how to improve their own property. That you didn't want to have, you weren't the contractor, you weren't a licensed contractor, and you didn't, as a result, you couldn't directly have any interaction with the subcontractors. If you came out and looked at the work, you would have to discuss your findings with the owner and not with the subs.
And that's providing the services directly to the owner, Your Honor. It is in providing the guidance and his education, experience, and ability to the owner in how to read the plans, how to manage the subcontractors, what the expectations of the subcontractor should be, when payments are actually due.
Well, but by that argument, you know, if I go to the University of Florida construction building program and I get my education there, and within the appropriate period of time come out and start building, and I don't pay my student loan or something to the University of Florida, they can come out and lien the property because they taught me how to be a contractor. That seems a little bit of a stretch to me.
Your Honor, in all due respect, with your analogy, that is a very broad, specific, and the people whom you would be helping are unknown and indeterminable at that time. At this time, there was a direct contract with a specific owner for the improvement of real property. And his services were, his knowledge and expertise was going to be given to the owner.
Does it make any difference if this was clearly in the construction phase versus the planning phase? Does that make any difference?
Yes, sir. If it was clearly in the construction phase versus the planning phase, the language.
Why would that make a difference? I mean, I'm still trying to determine what you did, what services you rendered to improve the property, other than giving advice to them as to how they can improve the property. So what difference does it make?
Well, Your Honor, to me, what the difference is, in answer to your question, is if he was in the construction phase, the contract says, let me back up, the contract can be terminated by either party at the completion of the planning phase, but before the commencement of the construction phase. Our position is that the planning phase had been completed, all monies that were owed had been paid, and that we were now into the construction phase. And once the construction phase begins, the contract clearly says that all fees owed to...
Well, let's assume that you were owed all the money.
Okay.
How does that give you the right to file a lien if you weren't doing anything to improve the property? They were.
Because we're now in the construction phase, and the appellant canceled the contract at that time, and thereby excluded my client from being able to perform, and waived his right to, or his obligation to perform.
What did you do to improve the property other than just give them advice? What exactly did you do?
Your Honor, there was...
Even if you, what would you have done even if you were in the construction phase to improve the property?
If my client were in the construction phase to improve the property, excuse me, he would have been there to assist the homeowner in clearing the property, laying the house out.
Well, it was the homeowner that was doing the improving, not your client. Your client was just giving them advice, right?
Yes, sir, and typically...
And you agree that your client doesn't qualify for any of these exceptions under the statute?
That is correct.
So we have to determine what improvements were made by you and with your client and whether those services did anything to directly improve the property, and does it have to be a direct improvement, or it can't be so tenuous as to go back to the person giving advice to the person that's actually making the improvements on the property?
Well, Your Honor, in this case, I would argue that Mr. Medellin was not going to be actually making improvements to the property himself either. All the work was going to be done through subcontractors, which he was going to be supervising, and he was going to be...
The only person supervising the subcontractors was the owner, right?
Yes, sir.
I mean, you couldn't even get involved with discussing any of these issues with the subcontractors because you're not a licensed contractor, right? You had to give the advice to them, and they had to give it to the subcontractors, right?
That is the way it was working, yes, sir.
And you call that improvements to property that was caused by your client as opposed to the owner?
My client would have been educating and guiding the owner to enable him to properly make those improvements to the property. So there is a direct correlation between my client's efforts in guiding.
So we would write an opinion saying that if you educate and guide, that's improvements to the property if you don't qualify for any of the exceptions under the statute. And that constitutes improvements to the real property, right? Is that what we're supposed to say in the opinion?
Yes, sir.
Okay.
And if I may continue, Your Honors, as far as it goes to attorney's fees and prevailing on the substantive issues, there were 4 issues. Under the complaint filed by my client was for breach of contract and to enforce a construction lien. Obviously, when the we lost on breach of contract, that was the basis supporting the construction lien. The lien went away. The other 2 issues were in the counterclaim filed by Mr. Medellin was for fraudulent lien and slander of title. And the court found that there was a good faith basis due to the ambiguities of the contract.
Didn't
Yes,
Susan Medellin prevail on the only issue that she had in the case?
Her issue, I believe, was for fraudulent lien.
She was not a plaintiff on the fraudulent lien claim, according to counsel.
Then if...
She was sued for breach of contract, correct?
Yes, sir, I believe so, she was.
And she won.
She won.
And why isn't she a prevailing party if that was the only issue she had in the case?
Well, she was the prevailing party on that, but there's also a case law, and TIREC is on point that in a construction contract or in a 713 lien contract, lien enforcement action, a party can win on the substantive issues, and the court can find that there is no prevailing party when it comes to awarding attorney's fees. And so going back on the fraudulent lien claim, the court found in favor of my client as there was no fraudulent lien, and similar with...
Did you plead entitlement to attorney's fees for the counterclaim?
No, sir.
And how are you entitled to fees? Or how are you entitled to say that there was a competing claim for fees there?
We're not arguing that, Your Honor. I did not do that trial.
All right.
And the counsel did only relied on the fact that the statutory language requires...
The only appropriate claim for attorney's fees was pled by the opposing party, right?
Yes, sir.
Okay.
But similar with the breach of contract issue being resolved in favor of the Medellins, that negating the enforcement of lien action, we had the same thing with the fraudulent lien. When that was found in favor of my client, UBUILDIT, that negated the slander of title. And on a slander of title, you can only be entitled to attorney's fees if there is an actual slander of title and there have been actual damages. And with the fraudulent lien, with the lien rather being found not to be fraudulent, there was no slander of title. And so what we've got, and the trial court ruled as to counts 1 and 2, that UBUILDIT did not prevail and that the Medellins should go hence without day. As to the counterclaim, the trial court ruled in favor of the plaintiff on both issues of the counterclaim. So we have the Medellins prevailing on 2 issues. We have my client, the appellee, prevailing on 2 issues. And the court essentially said, it's a draw, that the court could not find that one party prevailed without finding that the other party prevailed. And therefore, the court did not award attorney's fees to either side. Are there any further questions, gentlemen?
No?
Thank you, Your Honors.
Thank you.
I neglected to mention that the ambiguity in the contract as to whether money was due or not due did not affect whether or not there was a right to a lien, because all the monies that were alleged to be due were for loss of profit. There was absolutely no work that was done under the construction phase, even if they entered into the construction phase and technically the money is due.
Does it make a difference whether it was the planning phase or the construction phase?
It makes no difference, because no work was done on the construction phase.
Well, if it had gotten into the construction phase, would they then have a point that they had, rendered services that actually did improve the property, or does that even matter?
No, and they've conceded there was nothing done to the property whatsoever in any event. What they were alleging is lost profit claim. The $28,000 is you terminated the contract.
So is it your argument that even if they had gotten substantially into the construction phase and they were performing their part of the contract, that there still wouldn't be an improvement to the property?
Well, the first argument would still be that they are not the type of company or services provided that would be entitled to a lien in the first place. We would then go to whether or not the lien was for work actually performed on the property, for improvement of the property. Here we're talking about pure loss of profits. And the onion skin case that I cited, this 5th District Court of Appeals case, says we also note that Section 713.05 states that a contractor is permitted to have a lien on real property for money that is owed for labor, services, materials, or other items required by or furnished in accordance with the direct contract. The statute does not make any provision for increasing the amount of the lien based on alleged breach of the contract by the property owner. And that's what they're looking for, breach of contract damages. So we're not even talking about the monies being owed for work performed on the property. There's no dispute, none whatsoever. Even if they want to be considered a construction manager is not the type of entity which can claim a lien on property for unimproved property. It's specific. Architects, engineers, that's under Chapter 713.03. You have to be defined, and it has to be licensed as an engineer, a landscape architect. These are professionals that are doing specific work. They weren't with that as well. The Alfred Karam versus Cantor case that I cited in the reply brief considered that very issue and said if you're not an architect, at the time it was only architects who were allowed to have liens on an improved property, you're not allowed to have a lien on the property at all. And as a matter of law, it is fraudulent. As a matter of law, in the onion skin case, on a summary judgment, as a matter of law, it's fraudulent to put a lien for lost profit type of damages, which is exactly what they did. There was no basis for a lien whatsoever.
Does the onion skin case say that it's an objective or subjective standard in determining whether it's...
It is an objective standard, and you see it throughout the cases where you file a lien for the types of damages, for the types of things which are not lienable in the first place, then as a matter of law, it's fraudulent. And every single one of those cases say so. And we're talking about a summary judgment issue, where it was, for example, the onion skin case, they upheld a summary judgment on the issue of whether it's fraudulent or not. Under no circumstance, under no possible set of facts did the plaintiff, UBUILDIT, have a right to file a lien in this case.
Okay, your time's expired. Thank you both very much.
Thank you.